And I'm showing second counsel. Okay. Mr. Sherman, my understanding is here that you are present before the court on behalf of the appellant. In that regard, would you like to reserve time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal, please.
Thank you, counsel, and I will do my best to make sure that I notify you when you are thereabouts, if not earlier, right on time. You may begin.
Thank you. May it please the court, James Sherman on behalf of the South Florida Water Management District. We're here today, Your Honors, on appeal from 2 orders denying district's motions to dismiss. Those rulings should be reversed for 4 reasons. The court lacks subject matter jurisdiction because the requested relief violates the separation of powers doctrine and the district's sovereign immunity for planning level functions, because the court lacks subject matter jurisdiction where the parties failed to exhaust administrative remedies. The court lacks subject matter jurisdiction because the counterclaim seeks an adjudication of tribal rights under the compact, which cannot be adjudicated in state court. And because the court lacks subject matter jurisdiction because PV Ranch has failed to allege an adverse interest between the district and itself, which is required to invoke the subject matter jurisdiction under the Declaratory Judgment Act.
Mr. Sherman, my understanding is that by previous order, this court has indicated that it will hear this matter as an appeal from a non-final order regarding the issue of sovereign immunity. Is that correct?
That's correct, Your Honor, but nothing.
Okay.
I'm sorry.
Go ahead.
Nothing in the order eliminated the district's ability, as I understand it, to argue the subject matter jurisdiction arguments.
Okay. Well, let me shift gears, if I might, going on a different path. The order entered by the circuit judge, James Sloan, seems to be a rather standardized order that says the second motion to dismiss is hereby denied. Is that the correct order?
We're attempting to appeal both, Your Honor.
Okay. My question is, in 2018, the First District Court of Appeal dealing with appeals on sovereign immunity said that for purposes of this rule, an order denies sovereign immunity as a matter of law only when the order specifically states that as a matter of law, such a defense is not available to a party. Can we, on the face of Judge Sloan's order, get to this under the rule?
Your Honor, yes,
And I would say, I'm sorry to do this to you. I just came across that last night.
No, Your Honor.
Blame me, not the panel, blame me.
That was under the existing Rule 9.130. In 2020, the Florida Supreme Court entered an opinion in Jackson versus Florida Highway Patrol and ordered the amendment of Rule 9.130 to change it so that rather than requiring a determination on the face of the order that a party is not entitled to summary judgment or to sovereign immunity as a matter of law, the new rule looks to the substance of the motion and allows appeals from any order that denies a motion asserting entitlement to sovereign immunity as a matter of law.
So the generic will do it, because I know the First District spoke to, was it again? After that, I was going to ask you, but okay, I'm good. Thank you, sir.
Yes,
Is it your contention, Mr. Sherman, that the revised rule in 2020 allows to bootstrap all other non-sovereign immunity arguments into the non-final order jurisdiction?
In this case, Your Honor, it does, because the Florida Supreme Court in its rule, and candidly, Your Honor, I came across last night your recent opinion in the Sarasota County Public Hospital District, but respectfully, the district disagrees because in the in-rate amendments to Rule 9.130 opinion, the court essentially adopted by reference its opinion in Jackson versus Florida Highway Patrol, in which it expressed the express purpose of amending the rule was to ensure that issues of sovereign immunity are decided at the outset of the case rather than wasting public money until the end of the case.
And I'm sorry, Mr. Sherman, maybe I didn't ask the question clear enough.
Sure.
My question was, does the amended rule as of 2020 or 2021 allow bootstrapping, that is non-sovereign immunity issues, to be considered alongside sovereign immunity issues?
Oh, Your Honor, I'm sorry, I did misunderstand. I don't think we're raising anything other than sovereign immunity and subject matter jurisdiction issues. And so I think both are correctly.
The subject matter jurisdiction would be brought by writ of prohibition, not by
Correct.
non-final order appeal, correct?
Correct, and we did file a petition for writ of prohibition or alternative non-final appeal under 9.130.
I'm not sure candidly if all of the points that you've raised are properly wedged within the subject matter jurisdiction taxonomy, but please feel free to present your advocacy as you see fit.
Thank you, Your Honor. Certainly, this court does have jurisdiction on the sovereign immunity issues, but we feel that it also most of the same issues implicate subject matter jurisdiction. As to the first point, Your Honors, the requested relief would violate separation of powers, which is a subject matter jurisdiction issue, as well as the district's sovereign immunity for planning level activity. If you look at the prayer for relief, it implicates two different permitting programs of the district. The first is its right-of-way program, and the second is its consumptive use program.
Well, let's be clear what is being appealed here, because it struck me as I was reading through your briefs and as I'm hearing your argument, it's almost like the district is presenting this as if you had gotten all the way to summary judgment or gotten through a trial and had gotten these adverse rulings about who is responsible for maintaining the boards and who's responsible for upriver or downriver flooding or what have you. But that's not the posture of this case at all. This is on a denied motion to dismiss of essentially a deck action, which is a different kind of animal altogether from what you typically see, which would be like, an inverse condemnation claim or what have you. So help me out a little bit. Can you tailor your arguments to the procedural context of this? Why was this something that the circuit court simply could not even make a declaration upon?
Well, because the Florida Constitution,
without violating your sovereign immunity.
Because the Florida Constitution forbids one branch of government from usurping another branch's function. Here, the district has virtually unfettered discretion in administering its.
And Mr. Sherman, you're not seriously arguing that all of the district's executive functions and discretionary calls are beyond even the possibility of judicial review. Now, whether or not a court, how it goes about adjudicating rights and interests in disputed property is one thing, but to say that the court can't even review it, that's a leap too far, don't you think?
I don't think so, Your Honor. To get specific, if you look at Part D of their prayer for relief, they're effectively asking the court to issue a mandatory injunction against the district to adopt works of the district or to adopt the double culverts as a work of the district.
I don't read it that way. I read it as they're claiming, at least for purposes of a motion to dismiss, that there is a dispute as to whether or not this is a work of the district. And since it was constructed and built before the statutory implementation that gave rise to what the definition of works of the district are, we've got a dispute here. How is there a want of subject matter jurisdiction to determine a dispute? That's what the deck action is for. Because,
Your Honor, at the end of the case, the trial court is going to have to enter some sort of remedy, and if it rules in their favor, it's going to. That's key, right? If the court rules in their favor, then then arguably you have that issue come up, arguably. But we're not even at that point. We're asking the question: can the court even decide it? Can it even look at it? Because in theory, at the end of a bench trial, the court could find in the district's favor, right? And say, we find that this was not a duly adopted work of the district. It's on them. It's on PB Ranch. Respectfully, Your Honor, it turns into a political question as to whether the district is administering its discretion under sections 373.085 and 086 properly, and the court doesn't have jurisdiction to rule on political questions, and that's why it has to be decided at the outset. But moving on, Your Honor.
Mr. Sherman, and I guess not to belabor the point, help me out. Is it your argument that Judge Sloan actually ruled on the issue of sovereign immunity?
Well, Your Honor, the rule under 9.130 allows the appeal to proceed if we filed the motion that asserts entitlement to sovereign immunity. He denied that motion, and therefore we're entitled to appeal it. And so effectively under, as I understand the rule 9.130, he did deny our entitlement to sovereign immunity.
Okay, and that was my question. So he made a definite ruling, and that's what you're
Well,
taking
there's-
issue with, that he made a definite ruling that sovereign, on the issue of sovereign immunity. And this is what I'm just trying to understand.
Yes, Your Honor, there was no finding that there were issues of fact or that he had alleged issues. In fact, it's a pure issue of law as to whether the district is required to include operational criteria in right-of-way permits. And under section 373.085 and 373.086, the district has virtually unfettered discretion on how it administers its right-of-way programs because it implicates works of the.
No, that's not my question, Mr. Sherman. I guess my question follows Judge Lucas's and maybe Judge Casanova. Whenever a trial court makes a definite, and you're talking with two former trial judges, actually three of us, where whenever there's a definitive ruling made as to whether or not sovereign immunity basically applies or not, there's actually an order, a detailed order indicating that. In this case, because this was on a motion to dismiss, and I guess it dovetails what Judge Lucas is saying, help me out. Where did Judge Sloan made an actual definite ruling that you don't get the benefit, or going against the district that sovereign immunity doesn't apply here? Because there's some language later on. Didn't Judge Sloan said, hey, I don't know what's going to happen. I don't know. He may later on agree with you, but at this outset, at this juncture, do we have a definite ruling on that?
Your Honor, respectfully, I submit that under the Jackson versus Florida Highway Patrol case, the Florida Supreme Court expressed the policy that sovereign immunity has to be decided as early in the case as possible because it includes immunity from suit. And if this court does not review the issue of sovereign immunity as a matter of law at the outset, then public dollars are expended. And that's the express reason why the rule 9.130 was amended in the Jackson versus Florida Highway Patrol case.
I'm not sure, counsel, I'm not sure if it was to save taxpayers money or to conserve judicial resources as we pulled out our hair trying to figure out what the appropriate extraordinary writ that these things would fall under, because we were all over the map on that until the court amended the rule. So I'm not really sure it's in the interest of saving taxpayer money on litigation expenses as much as it is to just shepherd this into a silo that is readily recognizable.
Respectfully, Your Honor, I believe the express language in Jackson does cite to the public coffers. I'd be happy to look for that language
Okay.
while Mr. Jorgen's going. If I may move on to my other points, Your Honors, I'd like to argue about the other bases for error. The counterclaim expressly seeks an adjudication of the tribal rights, the rights of the Seminole Tribe of Florida under the compact, which is a federally recognized document, a compact, and the state court does not have jurisdiction to adjudicate tribal rights.
Wouldn't it be the tribe's position? Would it be the tribe that should be asserting that? Because this is not part of sovereign immunity, is it?
Well, no, Your Honor, but there's the tribe, the compact under its. I'm sorry, I seem to be having technical difficulties, Your Honor.
I'm hearing you okay.
Yeah, you're
Okay.
fine.
Me too.
I'm sorry, my video seems to be lagging. So excuse me if I pause or anything. The PV Ranch's counterclaim clearly asks the court to adjudicate tribal rights under the compact, but the compact can only be interpreted in federal court under its own terms and under federal law. Your
Yeah,
Honors?
I've got a lag there on my end here.
Okay.
I think
Your
I'm
Honor.
up again.
The last I heard you say, Mr. Sherman, was that the tribal compact can only be interpreted in a federal court, and therefore it's inappropriate to be heard here in the state court.
Okay.
That's
Fine.
correct, Your Honor, because the counterclaim expressly asks the court to interpret the tribe's rights under the compact.
Mrs. Sherman,
Um,
I had to draft you back for one moment, but I would like to clarify or elaborate upon a position Judge Kazam spoke based on your Florida Highway Patrol case. There's a passage in there that says, it's the duty, I think, of the trial court to determine entitlement to sovereign immunity as early as the record permits. And I think the question being propounded is based on the generic language of Judge Sloan's order. Do we know whether it has been denied as a matter of law in terms of entitlement or merely passed over to a later date until the record would permit? And that may be
Your Honor, I think
a construct.
if you look at the first order on the first motion to dismiss, he clearly says he thinks he has authority to decide these issues. Particularly, he says that he doesn't understand how the district is fulfilling its obligation under Chapter 373 in the way that it's administering its program, which clearly indicates he believes he can rule on the issues of planning level and discretionary activity by the district.
We're at 15, but we've taken up some of your questions at 15:45. I want to give you an extra minute so you can get to at least someplace where you would like to go to and still preserve your 5 minutes.
Okay, yes, Your Honors. Again, we assert that the parties hadn't exhausted their administrative remedies. And then finally, I want to get to the adverse interests. If you look at PV Ranch's affirmative defenses to D.L. Pierce's claims, they assert that D.L. Pierce has no right or entitlement to water downstream from the double culverts. If you look at that also is the district's position. So therefore, there's no adverse interest between the two parties. And under Brodigan versus McVicker, two parties can't be in agreement on the issue and then ask the court for an advisory opinion. May v. Holly's Florida Supreme Court case makes clear that an adverse interest is necessary to invoke the court's jurisdiction to make a declaratory judgment. So based upon those 4 reasons, Your Honor, well, we would ask that you would reverse the ruling below, and I'll save the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
Attorney Jorgensen, the floor is yours. You may proceed, counsel.
May it please the court, John Jorgensen for PV Ranch. When the court entered its order treating this case as a non-final appeal, I treated it as such, and the only issue that I addressed in my answer brief was the sovereign immunity issue. I did not address any of the other issues. I would note, though, however, that a writ of prohibition would not be appropriate because all of the issues raised by the district, failure to exhaust administrative remedies, failure to join indispensable parties, this compact issue they raised, the court clearly has jurisdiction to determine those issues. The district may disagree with how that jurisdiction is being determined, but writ of prohibition would not be appropriate because the court clearly has jurisdiction to determine these issues. Under the Florida Highway Patrol case, I do agree with the district that the court cannot just look at the order. The Florida Highway Patrol case has expanded the review of the appellate courts in these issues to look at the record as it does exist, and to look at in this instance, the motion, the response made by PV Ranch, the trial transcript, and looking at all those things, it's clear to me that Judge Sloan did not make a decision on the sovereign immunity issue. This case has a long history, and you can cut me off if you don't want to hear it, but I'll give you some of the facts. The history is almost 60 years old. It started back when the South Florida Water Management District was not in existence. It did not come into existence until about 1973 when the Water Resources Act under Chapter 373 allowed for the creation of the district. Back in 1962, it was the Central and Southern Florida Flood Control District, which I'll refer to as the Flood Control District, that was in charge of drainage and flood issues back in the day. There was a condemnation action under Common Law Case 593. There was a 1962 stipulation arising from that case in which the defendants, including my client's predecessors, agreed to compensation for a condemnation action that was brought by the Flood Control District to create this levee in the L59 canal, which would control the flow of surface waters and prevent flooding when water was flowing from the north to the south. So part of the compensation, in addition to monetary compensation, was the construction by the flood control district of the double culverts and the bridge, which would allow, and it also specifically allowed for headers, as they called them, or risers, and so that the owner of the double culverts at the time, and all successors, could control the use of the water in the L59 canal for the benefit of the defendants in the condemnation action, and also for the benefits of other users of the L59 canal. So this thing has been around for 60 years, and as stated in the complaint, which is part of the record, there's a long factual history in the complaint. The double culverts have always been used as a water control device. It was used by the flood control district. It was used by the South Florida Water Management District as a flood control device. And so you have these condemnation rights. You had common law rights that existed back in 1962. And then you have all these layers of regulation that happen after that by the creation of the South Florida Water Management District and by the enactment of Chapter 373. So it's a complex issue as to what controls the flow of water in the L59 canal. I mean, obviously the district is deeply into regulating the flow of that water and the drainage, because it has the power to issue consumptive use permits. But the reason we brought this declaratory relief action is initially this case was brought by a downstream water owner, D.L. Pierce Ranch, who was complaining that his predecessor, one of his predecessors in interest, was a defendant in the condemnation case, and he had a right to water from the L59 canal, even though D.L. Pierce does not have a consumptive use permit issued to it by the South Florida Water Management District. It started off as an injunction action, but it's later that injunction action there was an amendment to the complaint, and the injunction was dropped because at some point in time during this litigation, parties unknown removed the boards from the double culverts, and the water has been flowing freely ever since, because Judge Sloan has issued an order saying, okay, we're not going to mess with the boards until this case is over. And this created other problems, because without the water being staged at the double culverts, and the upstream water users, including consumptive use, including users that have consumptive use permits, when the water flows through during the dry season, they don't get their allocation of water under their permits. And it also affects the Seminole tribe, the Brighton Seminole tribe, because they have an agreement with the South Florida Water Management District that they're supposed to get 15% of the water that's available in the C40 and the L59 canal. So when the water flows through the double culverts during the dry season, they can't get their 15%. So the tribe has started, I think in 1918, by putting in their own plug in the canal during the dry season, and they get their allotment, and the rest and the other people downstream don't. And then, when it starts raining again, the tribe pulls it out. Perhaps the district is complaining for several months, but by the time they get around to actually doing something, then the tribe opens up the water and it flows through during the wet season. So my client, PV Ranch, is stuck in sort of a no-win situation. When the water doesn't flow through and they stage water, D.L. Pierce sues PV Ranch and claims that they're entitled to the water. In fact, D.L. Pierce currently has a claim against my client for causing severe damage to Pierce Ranch's cattle herd because of lack of water during a severe drought in 2017. On the other hand, if my client doesn't stage the water, which is the current situation, then PV Ranch doesn't get its allotment of water. It has a consumptive use permit. Other permit holders upstream don't get their allotment of water, and the tribe doesn't either. So we brought this declaratory relief action. The issue raised by the district in its second motion to dismiss dealt solely with whether or not these double culverts are works of the district. There are other issues that we raised in the declaratory relief action, including what obligations or rights does my client have to either staging the water or not staging the water? What rights does D.L. Pierce Ranch have to use of the water. So there are other issues. So even if the court were inclined to rule that Judge Sloan was wrong and at least denying the motion to dismiss as it relates to the sovereign immunity issue, there are other issues raised in the declaratory relief action which has not been addressed at all at the lower court. So the case would continue regardless if the court, ruled against appellee in this situation. However, I don't think the court should, because looking at the transcript, it's pretty obvious that Judge Sloan was wrestling with how to apply a current statute to nearly 60 years of history, how to apply the statute, when the district wasn't even in existence, when the double culverts were built. Look, the culverts have been operational for, nearly 60 years. They've acted as a water control structure, and the district just refuses to do anything about it. But without the staging of water at the double culverts, their system of consumptive use permits in the L59 canal does not work. And so these are the issues that Judge Sloan looked at. Judge Sloan denied the motion to dismiss in a rather generic short order, but if you look at the transcript, it's very clear. And we have to look at the transcript because that's what Florida Highway Patrol requires us to do. When we look at the record, including the transcript and the motion and the response, the judge said, look, I can't decide the issue right now. There's not enough here in the record. I might grant the declaratory relief. I might deny it. But at this point in time, I'm denying the motion to dismiss. The district's argument was very narrow. It dealt with this one issue about separation of powers and applying this statute 373.086 on what constitutes works of the district. It did not raise any other issues regarding sovereign immunity, such as planning versus operational and all those other issues that can become very difficult at times. That was their narrow focus. And the court looked at it and said, look, I can't make that decision yet. This is a statute. This is a current statute. I have to learn more about this case before I attempt to apply this statute and determine the issue of sovereign immunity. All these other issues. I mean, the first motion to dismiss was filed, I think, 27 months before the second motion to dismiss. And there was an order entered, I don't know, maybe 6 months after that. So there was never any, and the issues raised in that basically were failure to exhaust administrative remedies and failure to join indispensable parties. The district never appealed that order, and the district cannot raise all these issues from the first motion to dismiss in this very limited appeal of a non-final order. So again, my focus in the answer brief was to respond to the one issue that is appropriate for this court to consider, the sovereign immunity issue. Based on a reading of the record available on that issue, Judge Sloan simply did not make a decision on the sovereign immunity issue. And I don't believe Judge Sloan was required to make an issue because there were not sufficient facts in the record for the court to be able to make that determination. So unless the panel has any questions, I would respectfully request the court to uphold Judge Sloan's order and to send this case back down for trial.
Thank you, counsel. You have your remaining 5 minutes, Mr. Sherman, for rebuttal. You may proceed.
Thank you, Your Honors. Your Honors, if you look at page 15-16 of the Jackson opinion, the court stated every wrongly denied claim of sovereign immunity prolongs unnecessary litigation and siphons resources from the government entity's core mission. If you move on to page 18-19, the court went on to say, though the rule reflects an understandable concern for the limited resources of appellate courts, it leaves too great a risk, excuse me, that erroneous denials of sovereign immunity will go unreviewed until it is too late. It is the clear expression of the Florida Supreme Court that sovereign immunity should be decided at the outset, and that's particularly true with separation of powers issues. The court also stated on page 17, we also agree that precisely because sovereign immunity includes immunity from suit, entitlement to sovereign immunity should be established as early in the litigation as possible. That is especially true in light of the separation of powers principles that animate the doctrine of sovereign immunity. So it is the district's position that under Jackson, this court should decide this issue at the outset. One other point I want to make is that these
Does
issues,
the Supreme Court say at the outset in that opinion, or does it say as early as the record permits?
Your Honor, without rereading every word for it, I can't say definitively, but I believe.
And relatedly, Mr. Sherman, the point that you're belaboring about Jackson comes towards the end of the opinion after the Florida Supreme Court lays out the primary basis of its holding, which is that a textual statutory construction compels, including not necessarily compels a reading that allows a court to just simply look at the order on its and look at the corresponding motion to determine whether or not it's been denied or not. That was the
Right.
central thrust of the case.
And until the end of the case where they ordered amendment of 9.130.
Yes,
But
but they're at liberty to do that. We're not.
understandably, I want just to make another point, Your Honors, that this is really an administrative remedy that the party should be seeking. That's what the administrative process is for the court or for the ALJ to review the policy decisions of the district, and then on appeal to the District Court of Appeal, the district court is deferential to the factual determinations, but sees if the law was applied correctly. Here, because the claims clearly implicate issues that the court doesn't have a right to order to rule on because they're playing level activities, the district is entitled to sovereign immunity as a matter of law. And so, Your Honors, for those reasons, unless you have any further questions, we'd ask that you reverse the rulings below.
Thank you, counsel. Thank you both. This is an interesting case. I don't think we've had one like this for quite a while. So thank you for all your help and assistance in helping us to get through this. And please, on behalf of the panel, stay well. And
Thank
I
you.
will let you exit back whatever way the electronics take you.
Thank you, Your Honor.
Judge, stay well as well.